You may sit. Yes, so now we have arrived at the moment suprême. What we will do, we will give comments on the sessions, on the groups within the sessions. Justice Rajnath Lee will start with the first session, which is the University of Guyana against the Anton de Kom University. Comments on the performance and indicate which of those two was the better one, and also which of those four in that particular group would be considered the best orator. And so we will continue then to the next group, which is Cave Hill against the Puch. Justice Anderson will deal with that in the same way. Justice Rajnath Lee will then deal with St. Augustine, and I will deal with the last group. After that, we will give a very short idea of a possible outcome in this particular case. But we will be very cautious to do that, of course, because there may be cases that come in our direction. That's why we cannot be that clear as you may want us to be. And then we will, of course, which we already did, we already decided who has to get what kind of award. That has been given to the organization, and that will be announced thereafter. So that is the procedure. So, Madam Rajnath Lee.
Thank you, Justice Witt, and good afternoon to all. What wonderful 2 days we have had. And I want to say that the Moot, the session that I will speak about was interesting, it was enjoyable, it was lively. The advocates for the claimant came from the University of the West Indies, and they were Ms. Kalina Bulkan, Senior Counsel, Ms. Donnelly, University of Guyana, and I'm looking at it. Second advocate, Ms. Donnelly Costello. And the reserve was Ms. Rihanna McCurchin, and I hope I got all the names right. And from the Anton de Kom University of Suriname, first advocate, Mr. Anand Barrett. Second advocate, Mr. Durij Isri. And the reserve was Ms. Abigail Muhammad Damin. So excuse any mispronunciation of your names. As I mentioned, a good, lively, well-prepared teams. They understood their briefs. They generally stayed on message. As to content, we were satisfied that both teams had a good command of the materials and the international law principles that arose in the brief. We were particularly pleased that Senior Counsel for the University of Guyana, Ms. Kalina Bulkan, placed emphasis on the principle that Article 7 was not a standalone. And may we say that with a great deal of competence, we thought that she examined the relevant Chapter 3 rights. We thought that the University of Guyana could have placed some more emphasis on the provision of services, and I think that was acknowledged. But generally, we thought that their oral arguments were compelling, and in particular, Ms. Bulkan's. We were also impressed by Mr. Donnelly Costello's submissions on the issues of reciprocal arrangements and the jurisdiction of this court. As to strategy, both teams impressed us that they had worked out their strategy well. Their written submissions were well prepared, and the senior and junior counsel worked well together. As to ability to respond, these teams did not hesitate to answer what were generally very difficult questions. I do believe, however, and I think I speak for my colleagues when we say that next year when persons are asked a question, we hope we don't hear, "Thank you, Your Honor, for the question." It is assumed that you've heard it and you are grateful. Just answer as you did so well. As to style, we thought that the teams were generally skilled as advocates and that court etiquette was generally heeded. On an individual basis, we saw that the team representing the University of Guyana acquitted themselves well. Both senior and junior impressed us. And of course, that is not to say that the team from Anton de Com did not do a fine job as well. They did. And we thought both Mr. Anand Bharat, Senior Counsel, and Mr. Isri displayed their craft and their competence. And so we thought in particular that Mr. Isri was a disciplined and focused speaker, and we appreciated that very much, and we believe he will make a fine advocate. And so we are pleased to announce that the winner of this session is the University of Guyana. And we are further pleased to announce that the best oralist of this session is Senior Counsel for the University of Guyana, Ms. Kalina Vulcan. Congratulations to all. Congratulations, and back to you, Chair.
I just want to add that, of course, we all have to understand that the Surinamese students have to address ourselves in English, which is not their native tongue. And they did it exceptionally well. So I was kind of pleasantly surprised by that. So I'll turn now to Justice Anderson for the second group.
Thank you, Chair. The second group to compete, we had UWI Cave Hill against the Eugene Depuch Law School. And the members of UWI Cave Hill were Mr. Raim Augustin Joseph, Tariq Wilson, Fazah Momla, and the advisor was Dr. Eskin Burke. And for Eugene Depuch Law School, we had Natasha Rigby, Tamara Pinder, Shaquille Dean, and the advisor was Ms. Raquel Williams. Again, we thought that this was a very spirited, a very enjoyable moot. We thought that the mooters displayed significant knowledge of the material and significant skill in treating with the questions that were posed to them. I think we started off with a bang with Cave Hill, and in particular with Mr. Justin Joseph, who spoke to the issue of the non-discrimination under Article 7 of the revised Treaty of Chaguaramas. One of the things which was very impressive is that a question was asked about whether the case that he cited from Europe was a preliminary reference case. And he indicated at the time that he was unaware, but that he would give us the answer later on, and he did, which was, I thought, very, very good. But showed very good knowledge of the content of the treaty that we were interested in, linking the breach of Article 7 to various other articles in the treaty, 32, 36, and 46. Good strategy in that he foreshadowed what his junior counsel would speak to later on. Sort of run out of time and asked for more time, And one strategy might have been to have sought more time from his junior counsel. But nonetheless, we thought that he gave a good account of himself on that score. Ability to respond to questions, we thought that that was extremely good, very, very good ability there. And in instances where he did not actually know the answer, once again, he indicated that he would provide it in due course. He maintained very good eye contact. I thought he presented a very good, pleasant demeanor to the bench, and that he had a good cadence to his voice throughout. The junior counsel as well, I thought, gave a very, very good account of himself, Mr. Wilson. And I won't go through all of the parameters here, just to emphasize that I thought that he gave very, very excellent responses to the questions that were raised of him. He was extremely quick on his feet. I rather suspect he's a good dancer. But his responses were really, really fabulous and took me by surprise. And as those of you who know me, I'm not normally taken by surprise. One thing is that his voice dipped in one or two respects, so we had to strain to hear a little bit of what he said, but in due course, no doubt, that will be remedied, and I am sure he will make a fantastic orator and a fantastic advocate in due course. From the Eugene DePuch Law School, we also heard a very, very good team. I will say that we have had some fantastic teams from the Eugene DePuch Law School in the past. This one was, in all honesty, not quite as excellent or as reaching the highest level as those we have had in the past. And we understand that things ebb from year to year, but I thought that they gave a good account of themselves, and some very, very good points were made indeed. One or two places I think they felt sounded a little bit stiff, maybe a little nervous. Perhaps they were coming from so far away. I'm not sure why they were, but they were a little bit not quite as fluent as we have had in some instances in the past. But some very, very good points were made. And one of the points that stands with me here even now is the reference to a case from Europe, the European Commission against Belgium 2010, which dealt with the issue of whether the European Court of Justice can exercise jurisdiction in circumstances where a previous treaty regime does not, in fact, have the jurisdiction. That was, I thought, very, very good. So, two very good teams, teams that I think can be proud of themselves and which I think added significantly to this year's Moot. At the end of the day, however, as we are all aware, there can only be one winner. So after anxious and deliberate deliberations, we came to the conclusion that Cave Hill was the winner of that bout. And furthermore, we gave further anxious and deliberate consideration to who would have been the best oralist in this group. And the two persons from Cave Hill stood out, really, really stood out very, very well. But again, in the end, there can only be one winner. And we thought that, all things considered, Mr. Augustine Joseph was the best oralist. Okay, thank you very much, Chairman.
Thank you. Madam Rajnath Lee for St. Augustine, UE.
Yes, thank you, Chair. And the presenters for University of the West Indies, St. Augustine, were Ms. Celine Ducaran, their senior counsel, Mr. Dylan Kalu, their junior counsel, and Mr. Ronaldo Ramjohn, their alternate. This was, for those of us who were in the court this morning, a most eventful session. But for more than one reason. We thought that the attorneys were generally, and there were just two attorneys addressing us because there was no opponent. And may I just add that we did think that you may have been at a slight disadvantage, slightly hampered by the fact that you didn't see the response, the defense submissions. And so, like others, you would then have showed up your reply and so on. So we do understand that. But generally, you were well prepared. Although we did discuss with you, and we do think there were certain points, important points, that should have been on the table from the beginning. The written submissions, as I mentioned, and when I speak about content, the written submissions were promising because you considered that with Article 7, you could look at national legislation, and you could also consider state practice, those two together. But you didn't tie in the Chapter 3, substantive rights, and that was really crucial. So in a way, you were in advance of some of your other colleagues, but then you sort of fell back. So we understood that. But we did think generally good content, generally well-prepared submissions, but again, the Chapter 3 rights were omitted. We did think your strategy was good, and you both counsel worked well together. Ability to respond, we saw that nerves played a part in what you did, and don't worry, all of us experience nerves. We don't always show it. At least we are not supposed to, and anybody who does public speaking will know that, like me, I'm twiddling my fingers here, so I keep myself, So you learn the ways, you learn what you need to deal with those nerves. So I know that it will only get better for you. But generally, what we liked about St. Augustine is that you were so courteous. You were always so respectful. You were always respectful to us, and I just want to emphasize that we did on the last occasion speak about the importance of respect for your colleagues. No matter what you think of your colleagues' submissions, you must respect them. And we found that sort of respect coming from St. Augustine, and we appreciate. As the style, again, you were fair. We do think that if you had a better grasp of the principles of international law, you would have felt more able to address some of the difficult questions that you face. As the senior counsel, Ms. Celine Ducran, I want to say that we want to record publicly our appreciation and admiration to you, Ms. Ducran, for coming back after your incident, yes, and for completing your submissions. You are a credit to your family and to your institution, and I hope your dad is here, because I know he was here earlier. And we just want to congratulate you. You are a strong and courageous person. Thank you. And in all the circumstances too, Mr. Kalu, we thought that you must have been impacted by what happened, but you kept your cool, you moved on, you addressed us, you continued, and you stayed the course. So we want to congratulate both of you. We thought that, Mr. Kalu, you did a fine job, and you demonstrated great competence. So obviously, St. Augustine is the winner. And we did speak among ourselves, because it did occur to us whether we should name an oralist. And we think, having regard to what happened in the court today, we will not name a best oralist for this session. Thank you, Chair.
Thank you. Okay, well, you probably all know the saying that brevity is the soul of wit. So I will keep it brief. The last session was a very interesting one. We enjoyed it. We enjoyed actually every session, but this one maybe in a sense even more. We had two law schools here, I can say that especially the defendant, Norman Manley, their written submissions were solid. They were complete, almost complete. We must say the opening written submissions of the Wooding were a little bit, well, not really everywhere to the point. There were little remarks like under 8 or 9 where they refer to Nervais and Severin that it would show that the CCJ is quite capable of reminding the member states of their international obligations, and that we are not afraid to direct those states that where the domestic law is contrary to international treaty obligations, that it must be struck down and amended. Well, that was a little bit too much to say. Of course, you never tell a court that you are quite capable of doing that. That goes more or less without saying. But anyway, in the reply, of course, they had a good defense to react on. They were very much more on focus and more complete, and really went into essential issues. I have to say one thing about replies. This time we still had replies of 2 pages, but really we would suggest that replies should be limited to 1 page. Really, you have to say all your things from the start and only reply to a defense, and certainly if there are some new things. So that should always be short, even in written submissions. Anyway, that is for the future. In this case, it at least allowed Wooding to come back with more fulsome and pertinent submissions. So in terms of content, that is what I could say here. Strategy was good in both camps, so to speak. The ability to respond, there was an ability to respond on both sides. We did think that there was some hesitation at senior counsel every now and then, also with junior counsel, although they stood their ground, no doubt about that. They did well, although we think that the Norman Manley team was even better in that ability to respond, especially also junior counsel, who clearly knows the rule, stick to your point. And that's what she did, whatever we asked. In terms of the style, we thought that the presentation of senior counsel of Wooding was nice. It was personal, a personal start, giving the idea of, okay, I'm a community national. That was a very good beginning to start things. And it was also a very mature kind of presentation. So we thought that that was good. Junior counsel for Wooding also had a solid style. And of course, on the other side, the Norman Manley team had also a very good style. Of course, Mr. Richards, if I may put it that way, filled the room, but I don't mean it in a literally way, but in a way of oratory. And as we were also very much impressed by the way junior counsel, Ms. Nemmerd, stood her ground very well. This is what I want to say about these 2 teams. We, of course, had to decide a winner. We thought that the best team in this case, although, differences are not that big, but the best team was Norman Manley in this case, so they can be considered the winner of this particular session. And then we had to even make a more difficult choice, who would be the best orator in this session. And that was between Mr. Richards and Ms. Nemmerd. And although that was not much of a difference, but in the end, we appreciated the tenacity and the way she responded to our questions, slightly even better than Mr. Richards. So this honor goes to Ms. Nemad in this session. So now we come to what the court would decide, what we would decide. Well, the point is that I'm not going to tell you that. Because, as you know, there might be very well cases that come in our direction, and so we should not be too clear about that. But I will deal with the Article 7 issue very briefly. The point that were made, especially in the defense of Norman Manley, sums it up. We had it in other teams, also had it pretty clear. We had to look at discrimination. It's not a standalone issue. You have to look, but not just at precise, expressly indicated rights, but as I cite here from Douglas, Cardinal Douglas, Article 7 is not a standalone provision, but rather was adopted to ensure that the rights inuring expressly or by necessary implication upon persons of the community, that they were not thwarted because of discrimination on the basis of nationality only. So it's a little broader than just looking at the rights as expressly formulated. It is also about what is this about. So it could be reasoned that if you take that broad approach, and I'm not saying which one we take, but if you take that broad approach, then you could make a beginning with saying, okay, this might be discrimination. But of course it needs more than that. We need an objective justification, we need a legitimate aim and proportionate means to get there. Now, it is clear that an international court's perspective is different from that of a domestic court. Domestic court deals with the constitution, we deal with a treaty. So this is the same thing as, for example, if we deal with what is a fair trial, and the Inter-American Court of Human Rights deals with that exact same question. There might be different perspectives, there are different contexts. So, although you can use, of course you can look at the argumentation of domestic courts, it is not clearly of a decisive factor. So, then there was, of course, the issue of what kind of rights could this be connected to, and we had nice, interesting discussions whether that could be the right of establishment, whether that could be the right to provide services, or even the right to seek employment under Article 46. But as I said, it's not just limited to those articles, it's broader scope. Well, that was discussed, and by many teams, and in a very interesting way. And then there was, of course, the issue of Article 30. Now, if we just look at Myri, what was said there, you could get the impression that, okay, and as I mentioned that, okay, you can kind of discriminate as a member state if you talk about your military, your judiciary, because you could be then of the opinion that really that is too close to your national interests. The question here was, okay, does that extend to lawyers in general? There have been interesting arguments on both sides, and for this time we leave it at that. There will undoubtedly be a case, unless, of course, the legislation is being changed. You never know. Miracles do happen. But if that is not the case, then we could very well get such a case. And in that case, we want to be truly open to any argument given. But we must say those who are planning to bring a case, they should listen to at least the recordings of this session. They would have got a few interesting ideas how to get there. So this is what I wanted to say about the Article 7 point, and I will leave the CLE agreement point to Justice Anderson.
Thank you, Chair. And like you, I will be brief, or try to be brief, in relation to the Article 5 of the Council for Legal Education Agreement point. And that point, of course, was a suggestion that Trinidad and Tobago had breached its obligations under the CLE agreement by enacting Section 15(1)A of its Legal Profession Act. It is, in fact, a situation that we have several legal agreements which are relevant to the CARICOM integration project, but which are operated under separate legal agreements. And these legal agreements are, in a sense, divorced from the revised Treaty of Chaguaramas. So, in a sense, we are trying to superimpose the revised Treaty of Chaguaramas upon a fragmented legal infrastructure where there are no specific linkages between that umbrella agreement and these separate, distinct, almost fragmented legal arrangements. And that creates difficulties, and that creates problems, and that creates, I think, the need for us to begin to reimagine how we could make the two things more in sync and more cooperative with each other. So, as we know, Section 5 of the CLE agreement imposes a clear obligation on states not to allow persons to the practice of the law who do not have the LLB or the LEC. Trinidad and Tobago, in enacting the Section 15(1)A provision of its LPA, has apparently, and you see, of course, I do have some legal training, apparently breached that provision in the CLE agreement. And when we look at the cases that have come before the courts in Trinidad and Tobago, there's little contest that this, in fact, has happened. And what has happened in the High Court and in the Court of Appeal is that these courts have said, well, we are not in a position to pronounce upon any alleged breach by Trinidad and Tobago of the CLE agreement. That is for international courts. That is not for us. That's for a matter for the members of the agreement establishing the Council for Legal Education. So, in a sense, there's an easy way out for the domestic courts in Trinidad and Tobago. Unfortunately, that easy way out is not available to us because we are an international court in the original jurisdiction. Our jurisdiction in this respect is conveyed by Article 211 of the RTC, which gives us the power to interpret and apply the provisions of the RTC. And we do that in relation to disputes among member states of the community. Now, there have been several cases where this court has said that the only defendant that can come before us is a member state or the community. But in the case we had today, there was in fact before us a member state. So that was satisfied, if you will. And the complainant states were also member states. So this was in fact a dispute between member states of the community. And the question then was whether the CLE agreement was relevant to the interpretation and application of the RTC. Because if it was so relevant, then it of course would fall within the jurisdiction of the CCJ. Now, that is a very difficult question as to whether the connection between the CLE and the RTC is so intimate and so close that it is necessary that we have recourse to the CLE in interpreting the RTC. Some arguments were made before us which we were not too persuaded by. One very ingenious argument was that, well, the CLE has no other dispute resolution mechanism. And if you turn us away, if the CCJ does not take jurisdiction over this matter, then there's nowhere else to go for litigating any breaches of the CLE. I think the case cited by Eugene Depuche was a good answer to that, as to say that the mere fact that there's not an alternative forum does not necessarily mean that this forum has jurisdiction. So that was an interesting point which we were not sure we were necessarily persuaded by. But there was another point that was made having to do with the umbilical relationship, which I mentioned earlier, between the CLE and its organization of persons into a cadre of individuals who can provide legal services to the community, on the one hand, and on the other hand, the provision in the RTC, which carves out a space in the community for community nationals to provide legal services. And we wondered if the overlay of those two regimes might not provide a basis for us to say, well, yes, we can have a look at the CLE in interpreting the provisions of the RTC. We were strengthened in that way of thinking because of provisions in the revised treaty, not the revised treaty, I'm sorry, the Vienna Convention on the Law of Treaties, which allow for a court to consider legal rules binding between parties to it in coming to a decision on the interpretation of a treaty. And as I said earlier, that provision has itself been accepted by us in the Rock-Hard case. So, like my senior brother to my left, I'm not going to make a definitive conclusion on this point. But what I would say is that we should not interpret the Jason Jones case as putting an end to this question, because all that Jason Jones decided is that the CLE could not be a defendant in the case before it. But in that case, this court did make certain pronouncements upon the CLE, and likewise it is possible that in the future this court might feel compelled to make pronouncements as well upon the importance of member states observing their obligations under the CLE. Thank you, Chair.
Thank you very much, Justice Anderson. Well, then that brings us to the conclusion of this particular part. We hope that this was a good learning experience for all you. And I can tell you that these sessions are always also a learning experience for us.
Yes.
At least I speak for myself, but I think I speak on behalf of both my colleagues, because you always get fresh and new perspectives and some things that at first sight you wouldn't have thought of, and the students bring them out and in a very pleasant way. So this is why we are never bored or ever anything to do this kind of moot court. We like it. We certainly not in the position of the man who was dreaming that he was sitting in the House of Lords, and when he woke up, he was. So that didn't happen to us. We were very much alive to what happened here. So thank you very much, and we will hand over to the Master of Ceremonies, who will now tell us to descend, I suppose, or can we stay here?
I think he said descent.
Descend. Okay, well, not descend, huh? But descend. So, thank you.
Okay. Good afternoon, everyone. Please allow me to acknowledge the Honorable Mr. Justice Adrian Saunders, President of the Caribbean Court of Justice, our host for this afternoon. Senator the Honorable Dr. Amory Brown, Minister of Foreign and CARICOM Affairs of Trinidad and Tobago. Senator the Honorable Renuka Sagram Singh Suklal, Minister in the Office of the Attorney General and the Ministry of Legal Affairs. Members of the Diplomatic Corps and Consular Corps, we have His Excellency Peter Cavendish, Ambassador and Head of the EU Delegation to Trinidad and Tobago, and Her Excellency Ms. Jennifer Marchand, TT Ambassador to CARICOM. We also are joined by other members of the Consular Corps, Bahamas, Guyana, and we have the Grenada Trade Commission Office here, representative here. Mrs. Gabrielle Figaro-Jones, Registrar and Chief Marshal at the CCJ. My apologies, and judges, that was a slight, and let me repeat that again. The Honorable Justices Witt, Anderson, Rajnath Lee, and Burgess, judges of the Caribbean Court of Justice. Mrs. Gabrielle Figaro-Jones, Registrar and Chief Marshal. We're also joined by the Honorable Mr. Justice Westman James, Judge of the Trinidad and Tobago Judiciary, principals and deans of participating institutions, management and staff of the CCJ and the Regional Judicial and Legal Services Commission, our 2023 Mooters, the advisors, members of the Moot Registry, other specially invited guests, all those following online via YouTube, welcome to the Caribbean Court of Justice and to the closing and award ceremony for the 13th Caribbean Court of Justice International Law Moot Competition. So many of you may have visited us before, but for those who are here for the first time or after a long absence, I extend a very warm welcome to you to the seat of the court. So my name is D.K. Noel. I'm the Chief Public Education and Protocol Officer. And it is indeed a pleasure to stand here as your host for this afternoon's ceremony. The annual CCJ Law Moot Competition is an exciting time for us at the court because it provides us with the ideal opportunity to welcome students from across the region and at the same time help them understand the revised Treaty of Chaguaramas, for which the court has primary jurisdiction. In preparation for this event, the court is mobilized and there's extra excitement as we put out all the stops for this hallmark occasion. So over the last 2 days, our students showed up, they presented their arguments to the best of their abilities, and they certainly did their best. So I ask you to join me in giving them a round of applause, please. So ladies and gentlemen, the planning of this 13th CCJ International Law Moot Competition began in November 2022, under the guidance and direction of the Honorable Mr. Justice Andrew Burgess, who once again served as chairman of the committee, of the steering committee. With his calm and encouraging disposition, Mr. Justice Burgess led the steering committee and 2 subcommittees. And I was very happy to be part of this committee and to work with Justice Burgess. It is therefore fitting, ladies and gentlemen, for us to hear from the steering committee of the CCJ Law Moot Competition, the Honorable Mr. Justice Andrew Burgess.
Thank you, Master of Ceremonies. Good afternoon, ladies and gentlemen. After hearing the protocol established by the Master of Ceremonies, I'm certain that you will permit me to adopt the protocols as they have been established by him. And to say again, good afternoon. As chairman of the CCJ Law Moot Committee, I would like to extend warmest welcome to all of you to this closing ceremony of the 13th annual CCJ International Law Moot Competition. This was our first in-person moot since 2019. And I must confess that I was totally impressed by the enthusiasm and dedication demonstrated by you, the participants, and by the extremely high caliber of your arguments presented before the judges. Our crafty judges raised some tricky questions with you during the oral presentations. You dealt with these questions admirably. When you knew the answers, your responses were absolutely brilliant. When you did not know the answer, you definitely sidestepped the questions. The parrying between the wily bench and the young Mooters was thoroughly enjoyed by us, the audience. May I bestow my sincerest congratulations to all this year's participants. You did yourselves proud, and your institution as well. Since 2008, this Moot competition has been a marquee event in the calendar of regional law schools and law faculties. We at the CCJ are aware of the importance of this competition in contributing to a Caribbean perspective to our up-and-coming lawyers. Accordingly, the objective of the Moot has always been to provide an opportunity to educate and foster greater interest on the workings of the revised Treaty of Chaguaramas and the development of the jurisprudence in the CCJ's original jurisdiction. In hosting this Moot, we wish to show our investment in you, the future attorneys of the region. The issues of this Moot are issues which have arisen or may arise in some fashion during your career. And who knows, you may appear before the CCJ in the future litigating these and other issues. As a former dean of the University of the West Indies Faculty of Law at Cave Hill, I have witnessed the strengths that can be developed and the weaknesses that are discovered by students through a mooting competition. The entire experience, from preparation of arguments to standing before the court and making those arguments, improves a participant's overall understanding and knowledge of the area of law, in this case, community and international law. Students gain invaluable experience and training in written and oral advocacy, coupled with the honing of legal research, analytical, and reasoning skills. This knowledge and these skills are and will be valuable and eventually considered as advantageous by your future employers or by yourselves, should you choose to practice on your own. Simply put, the Moot experience will no doubt be remembered by you as a defining landmark in your development as attorneys and jurists. I can only hope that the preparation of the Moot has assisted in your awareness and understanding of community and international law and the CCJ's original jurisdiction. You are here to represent the states of St. Lucia, Grenada, and Trinidad and Tobago. In reality, however, you represented yourselves and your respective schools and showcase your skills in advocacy, in research and reasoning before some of the finest and most distinguished jurists in the Caribbean. Again, I say that you should be proud of this achievement. I'm pleased to announce that this year we have introduced the Sir Henry Ford Best Oralist Award, which will be presented to the mooter who played the great oratory and advocacy skills Sir Henry de Boulay Ford is so well known for. He is the most distinguished he is a most distinguished and respected attorney in my home country of Barbados, and indeed in the wider Caribbean. After being admitted to practice in 1959, he embarked on a long, illustrious career in law, academia, and government. Sir Henry became a member of Parliament in Barbados in 1971, and over the course of his distinguished political career, held the position of Attorney General, Minister of External Affairs, Opposition Leader, and Leader of the Barbados Labour Party. In Barbados, Sir Henry is regarded as an advocate for women's rights, advocating for the reform of legislation with respect to women and children, and successfully proposing the establishment of a national commission on the status of women. Notably, he has a special place in CCJ's history, as he led the legal team for the first case to reach the CCJ in 2005, the Barbadian case of Barbados Rediffusion Service Limited and Merchant Danny. His outstanding contributions, high standards of advocacy in Barbados and in the wider Caribbean, explains why it is only fitting that his name be associated with the Best Oralist Award. Before I close, I would like to personally thank my brothers and sisters on the bench, Justices Witt, Anderson, and Rajnath Lee, for dedicating their time to this year's competition. We truly appreciate their use of the Socratic method in making the moot an enthralling experience. I must say I'm not too certain if the mooters always appreciated the questions which they raised. As chair of the Law Moot Committee, my appreciation is also extended to the members of the Moot Steering Committee, the subcommittees, and all those who tirelessly dedicated their time and energy to the staging of this competition. A very special thank you to each and every one of you, the students and advisors, for participating in this year's Moot competition and contributing to what I consider the resounding success of this year's Moot. For those of you who travel to participate, I hope you've enjoyed your short stay in Trinidad and Tobago. I must finally extend my sincerest congratulations to this year's champion team to be announced on your victory over the other teams to win the CCJ Shield. I thank you.
Thank you very much, Justice Burgess. And a takeaway for me was his sentence: the Moot experience will no doubt be remembered by you as a defining landmark in your development as attorneys and jurists. So I do hope that you all remember that sentence in particular. So the overall support that we received for this year's Moot came from our president, the Honorable Mr. Justice Adrian Saunders. He's a driving force behind this competition, and he wholeheartedly believes in the Moot. Yesterday, in his opening address, he told us that our role is to foster a regional legal culture, to support the development of Caribbean jurisprudence. This is a responsibility we have really and readily embraced. Hosting the Moot is a testament to our commitment to strengthening the rule of law and embracing justice delivery throughout the region. Today, as the Moot ends, it is fitting for us to hear from our president. Ladies and gentlemen, please join me in warmly welcoming the Honorable Mr. Justice Adrian Saunders.
Thank you very much, Mr. Noel. And again, I will follow my brother judge in announcing my observation of all the protocols. I want to pay special attention to the Honorable Minister. Thank you for your presence here. My colleague judges, of course, and all the distinguished guests who are here with us, students. It has only been 18 years since this court was inaugurated. 18 years since the English-speaking Caribbean region is able to boast of having its own apex court. 18 years since the regional integration movement within the Caribbean community was transformed into a rules-based system with a dedicated court entrusted with, where necessary, giving effect to or advising on the rights and obligations enshrined in the revised Treaty of Chaguaramas. 18 years is not a long time. The Judicial Committee of the Privy Council that this court has replaced in 4 states at this point in time existed for hundreds of years. The U.S. Supreme Court was established in 1789. The Court of Justice of the European Union was established in 1952. So when you compare 18 years with those periods of time, it's a short time. And so we have a fierce urgency to disseminate to the people of the region as much information as possible about their court, about your court, about our court. Who are the judges? What are they like? Who comprise the staff? How does the court go about its work? What kind of technology does the court employ? Is it a court whose decisions can be trusted? What is the courtroom like? Is this a court that is efficient and effective? Especially as in some respects, at least in one of the 2 respects, it is replacing a court that has existed for hundreds and hundreds of years. The people of the region deserve answers to these and myriad other questions. And it is because we recognize this that, as I'm sure you would have witnessed yourselves, hosting this international law moot, it enlivens the court in a very distinct way. Preparing for and facilitating the competition, it energizes our planning committee, ably led by Mr. Justice Burgess. The moot is one of the few activities that we have at the court that embraces, in one form or another, every unit of the court. And we could name them. You look around, you see them. Our security officers, our library, our finance department, our registry, of course, our judicial council, our protocol, our judges, of course. Every unit of the court is activated in order to support the moot. And organizing the moot is one method we have devised for responding to all of those questions that I posed earlier, which are legitimate questions that people of the region are entitled to receive answers for. The moot is an opportunity for us to enjoy and build a meaningful relationship with stakeholders we don't usually encounter when we attend to our core remit of receiving and resolving matters that are filed before us. From what I observed yesterday and today, and based on other feedback that I've received, I think it is only fair to say that this year's cohort of students has continued the tradition of excellence that has been set by past teams. You all have worked very hard, and in the process, you have ensured that the 2023 Moot has been a tremendous success. Each Moot we have, we keep saying that, but it is true that each year, it seems that the standard of advocacy grows, it rises each year. The winners were announced of the various moots, but I want to say that the Eugene Dupuche Law School, they probably have come here from the furthest distance. They're further than Jamaica, probably. The University of the West Indies, St. Augustine, of course. The Hewarding Law School, and the Anton de Com University, all did very well. And in particular, I'd like you to give a rousing round of applause to the students from Suriname who had to participate in what was not their native language. Happily, we have on our bench Mr. Justice Witt, who is Dutch speaking, of course, is Dutch by birth. He's Caribbean now. Who constantly reminds us that we have to make a special effort to embrace our Surinamese students, our Surinamese brothers and sisters. They are just as much a part of CARICOM as Jamaica or Trinidad or Grenada or St. Vincent and the Grenadines. And so we are always very thrilled when students are able to attend and participate in the Moot. As those of you who are here this morning know, Ms. Dukaran unfortunately had a little mishap this morning. She later insisted, after she had recovered herself, that she must complete her presentation, and she did so to a rousing round of applause. Arrangements were made for her to be seen and treated, and I'm happy to report, and you can see for yourselves, that she is in fine form. I must also indicate, sadly, that Mrs. Shaista Nabibax, the Moot advisor for the Surinamese team, received the shattering news today that her grandfather had passed away this morning. Now, under any circumstances, such news must be devastating. Ms. Nabibax, I know that each of us here, as well as the judges and staff of the court, would join me in extending our deepest condolences to you and your family members on your loss. In a few moments, the individuals and teams will walk away with the awards for this year's Moot will be presented with those prizes. But by participating in the proceedings over the last 2 days, each of you is a winner. In exchange for the considerable time and effort that you have put in, you all now know much more about the revised Treaty of Chaguaramas, and in particular about the freedom to supply services. Your knowledge about the court has increased tremendously. The competition has allowed you the opportunity to interface with the electronic systems, the infrastructure, the processes that we have here at the court. You can truly now count yourselves among the relatively few in the region who have presented arguments before 3 of the most senior judges in the region, the very judges who sit to hear and deliberate upon matters concerning the RTC. Come to think about it, you can probably answer all those questions I posed at the outset. And of course, those of you who hail from overseas in particular, must have had, I'm sure, some unforgettable experiences to share when you return home about Trinidad and Tobago. Unfortunately, I was only able to hear the presentations of some students, but I was extremely impressed by the confidence and the clarity of the speakers, by the cogency of the arguments presented, and as some of the previous speakers mentioned, by the skillful interaction that I saw with the bench. In some moods in the past, as I said to one of the groups with whom I had lunch, and Justice Hayton used to comment about it, we would receive presentations where the mooters would speak at the judges and not speak to them. Happily, throughout the time that I personally witnessed the presentations made, in every case, the speakers were speaking to the judges. They were personable, they were responsive, and they spoke in a modulated tone that was conducive to the interactions that we saw displayed throughout the last 2 days. And so I thought to myself, the future is in very good hands. But more than this, I must tell you that for us, judges of the court, your research, your presentations are not merely an academic exercise. Each year, the Moot organizers deliberately craft a brief that approximates issues which we anticipate will arise under the revised treaty. And your presentations, your research, your arguments are archived so that as and when such disputes actually come before us, we would have a head start in analyzing the various issues. This year's Moot had two significant features. First, it presented a scenario where all the parties before the court were member states of CARICOM. And secondly, it concerned an issue very close to the heart of those who study law with the intention to practice. What is noteworthy about the first feature is that to date, there's only been one instance in which a CARICOM member state has filed a claim against another in the original jurisdiction. This was the matter of the state of Belize against the state of Trinidad and Tobago, in which we delivered judgment last year. I think the significance of the second feature is self-evident. Without saying much more on the point, I hope by now you have seen how the rights and obligations under the treaty can have a very real impact, not only on the relationship among states parties to the treaty, but on the lives and livelihood of community nationals, perhaps yourselves or your colleagues, or even a family member. Having gone through the experiences you have over the last few days, I would like to think that each of you can now be counted upon to be worthy ambassadors. Ambassadors for impactful regional integration, ambassadors for excellence within the legal profession, and ambassadors of the Caribbean Court of Justice. Now, there's never a free lunch. The role of ambassador carries with it responsibilities. And so we ask you to discharge those responsibilities well. For example, the court maintains a website and a lively social media presence. And so we encourage you through these media platforms to keep abreast of what is taking place at the court. And with the CARICOM single market and economy, CARICOM as well has a very lively website. Before I close, I wish to extend again heartiest congratulations to all the teams that participated in this 2023 Moot. I extend my appreciation to the principals, the deans, the advisors from the Faculty of Law of the Anton de Kom University of Suriname, the Eugene Dupuche Law School in the Bahamas, Hewling Law School here in Trinidad and Tobago, the Norman Manley Law School in Jamaica, the Department of Law of the University of Guyana, the University of West Indies at St. Augustine, also here in Trinidad and Tobago, and the Faculty of Law in Cave Hill, Barbados. I also wish to reiterate that our thoughts and prayers are with you at this time, Ms. Nabi Cox. And lastly, I offer congratulations to Mr. Justice Burgess and his team, and indeed the entire management and staff of the court and the Secretariat of the Regional Judicial and Legal Services Commission for a well-executed event. And I thank all of you, our specially invited guests, and those of you following these proceedings online for your support that you have given by your presence, by your participation to the Mooters and to the various teams and this annual competition. Thank you very much.
Thank you very much, President Saunders. And Mooters, you all would have heard, President, you all were confident, you all were clear, you all displayed skillful interaction with the bench. And those are things I really hope that you all remember as you go back and continue with your studies. So most of you will be aware that last year, because of the COVID pandemic, we convened a virtual Moot competition to enhance the experience in the digital space. We introduced a social media spirit prize to raise the profile of the teams, help increase camaraderie, and extend involvement of the Moot to the wider academic community and the public. We hoped that the show of support and positive feedback from the competition, from the online community, helped to boost the participants' confidence leading up to the competition. So the winners of this year's Social Media Spirit Prize received an Amazon gift card valued at US $50 and a publication donated by the CCJ Academy for Law, thank you very much, Justice Anderson, for the school's library. So as at midday, the institution which had garnered the greatest online support, positive comments, feedback, and engagement was the Norman Manley Law School. So it is at this time, I invite the Communication and Information Manager, Mrs. Ria Mohammed Pollard, to come forward and present the students with their Amazon gift card, which we hope you all will use wisely, and also to receive the publication for your school's library. Mrs. Mohammed Pollard, you could come forward, and the students, you could also come forward to get your prizes. That's good. Okay. Just Ria one second. So congratulations again, students, and I guess you have to thank your supporters and your online community, and maybe it may be up to you if you wish to contribute any of that prize to them. So each year, the Faculty of Law at the University of the West Indies St. Augustine campus provides us with students who work as officers of the registry. They perform the tasks of registrar, deputy registrar, multimedia officer, marshal, court support officer, judicial counsel, and other critical roles. Sometimes they double up. Yesterday, they exchanged, so we had a different registrar in the morning and another one in the afternoon. So similar to any court, the registry is the engine room, and the workers therein are critical. I therefore invite these students to come forward when we call your name to receive your certificate of participation. But in the interim, I asked Mrs. Heather Dyer Thompson. She is the registry supervisor. She was like the mummy and the auntie over the past few weeks, to come forward and assist with the distribution of the certificates, please. So first up, I call on Miss Vishala Jabbar. Miss Michaela Misson. Miss Dejanot Montez. And Miss Maya Francois. Thank you, Mrs. Dyer Thompson. I now invite our registrar, Mrs. Gabrielle Figaro Jones, registrar and chief marshal, to come forward and distribute the remaining four certificates, please. And we'll continue with Ariana Bire. Miss Shamika Nelson. Followed by Miss Solange Joseph. Our court multimedia officer, yes, she was in the back completing her last task. And Miss Jade Montrose. I wish to thank our registry supervisor and our registrar and chief marshal for assisting us this afternoon. Okay, so this is the point that Justice Witt kept alluding to. So I will announce the schools that will receive the bronze medals and certificates. And these are the schools, the institutions that performed creditably but did not receive the judge's nod for the silver or gold. These institutions are University of Guyana, Anton de Com University of Suriname, Eugene Dupuche Law School of the Bahamas, the University of the West Indies, St. Augustine, and the Hugh Wooding Law School. So these schools will all receive bronze medals and certificates. And I therefore now invite the Honorable Mr. Justice Andrew Burgess to come forward, please, and assist with the presentation of the certificates and medals to students of the University of Guyana. And we will call on Kalina Bulkan, Don Lee Castillo, and Rihanna McCurchin. Thank you very much, Mr. Justice Burgess. And I now call on the Honorable Madam Justice Rajnath Lee to assist with the presentation of certificates and medals to the students of the Anton de Com University of Suriname. And we will start off first with Anand Bharat. Tirej Israel, and Abigail Mohammed Amin. Thank you very much, Madam Justice Rajnath Lee. And congratulations again, Anton de Com. I now call on the Honorable Mr. Justice Anderson to present to the students of the Eugene Dupuche Law School of the Bahamas. And we will start off with Natasia Rigby. Tamara Pinder. And Shaquille Dean. Thank you very much, Mr. Justice Anderson, and the head of the panel, Mr. Justice Witt. I ask you to come forward, please, and present to the students of the University of the West Indies, St. Augustine. Celine Dukaran. Followed by Dylan Kalu and Ronaldo Ramjon. Thank you very much, Justice Witt. And a big round of applause to the University of the West Indies, St. Augustine. I now invite the Trinidad and Tobago Ambassador to CARICOM, Her Excellency Miss Jennifer Marchand, to come forward and present the certificates to the final bronze recipient, which is the Hugh Wooding Law School. Amoy Gilding Bourne, followed by Devi Ramnarayan, and last but by no means least, Akinola Goodridge. Excellency. Your Excellency, thank you very much. So we now move on to the award for Best Academic Institution. And this is awarded to the academic institution, that is the non-law school in simple terms, which in the judge's opinion has performed exceptionally well and distinguished themselves from the others. So this year, the winner of the Best Academic Institution is the UE Cave Hill Campus, Barbados. I now ask His Excellency Peter Cavendish, Ambassador and Head of the European Union Delegation to Trinidad and Tobago, to present this plaque to the best academic institution from the University of the West Indies, Cave Hill. Sure. So for photo purposes, we'll give the plaque first, and then we'll give the certificate so that you could capture your images very quickly. So we kept it all under wraps, neat and shiny just for you. Ambassador? Thank you very much, Ambassador. So this year, we introduced the Sir Henry Ford Best Oralist Prize to recognize the Mooter whom the judges believe best embody the essence of his or her role. Someone who was recognized for his or her oratory and advocacy skills during the competition. As Justice Burgess stated earlier, Sir Henry Ford led the legal team for the first case to reach the CCJ. So the winner of the inaugural Sir Henry Ford Best Oralist Award is Mr. Raheem Augustine Joseph. And I call on Senator the Honorable Renuka Sagram Singh Suklal, a fine oralist herself, to distribute this prize to the best oralist, Mr. Raheem Augustine Joseph. Thank you very much, Minister. So the silver medals, that is the team that is, in the judge's opinion, the second best overall participant, the team that they believe fits everything that they found in terms of all the criteria. It matched everything that they wanted to see. This team to receive the silver medal in the 13th annual CCJ International Law Moot Competition is the University of the West Indies, Cave Hill campus. I now call on Senator the Honorable Dr. Amory Brown, Minister of Foreign and CARICOM Affairs of Trinidad, to present the certificates to this group. And we will start off with Faiza Mumla, thank you for the clarification. Tyreek Wilson. And Mr. Raheem Augustine Joseph. Thank you very much, Honorable Minister. Well, by process of elimination. It is evident that the winner of the 13th annual CCJ International Law Moot Challenge Trophy is the Norman Manley Law School. Comprising Ronaldo Richards, Adelia Nemhard, Akelia Richards. And I now invite our president to one first. We will do the, it's a lot of prizes. So it's your certificates, it's a publication, it's an Amazon gift card valued at 100 US, sorry, I was increasing. This is the man to give you more. You can speak to him. But he will first distribute the smaller prizes, and we go with the certificates because it will be a lot to hold at the same time. So we will start off with. Yes, those are fine. Ronaldo Richards will be presented with his certificate and gold medal first, and then we will follow with Adalia Nemhard.
This is for Ms. Lemma.
Yes, Ms. Nemhard, yes. President, the honor that you do. So, ladies and gentlemen, the Norman Manley Law School out of Kingston, Jamaica. And they're calling their advisor forward. Sure. And I think it's also fitting that we recognize all the team advisors who have played a great role in bringing their teams to this point. They are seated in the area over there, all over, but I know that they really worked hard, and I know that they really contributed to their students' success today. So as the formal event comes to a close, I would like to invite Mrs. Gabrielle Figaro Jones, Registrar and Chief Marshal, to deliver the vote of thanks, the closing remarks, and then we can toast to our students' achievements. So ladies and gentlemen, our Registrar and Chief Marshal.
With all protocols having been formally established by the previous speakers, I wish to adopt these protocols and wish you all a very warm welcome. Trials can be daunting. I am certain that every instructing or advocate attorney at law, past or present, can remember his or her first trial. I remember being unable to sleep the night before or eat the morning of. I felt like my bands and robes were smothering me. But soon enough, the matter was called, appearances were entered, and we were off. The anxiety is inevitable, and it's common. But one of my few comforts at that time was knowing that I had done something similar in my uni days. The annual Caribbean Court of Justice International Law Moot Competition is an opportunity for the court to honor its unofficial social responsibility, which is to help prepare upcoming attorneys for the world of work. This competition provides us with the opportunity to engage, interact, and help pave the way for the students who will be soon practicing and living their vocation. It also aligns with the court's strategic plan, improved communication, and stakeholder engagement. It is the new generation of lawyers that will be an integral agent in the court's information dissemination and public education agenda. Through the Moot, law students are able to increase their knowledge and deepen their understanding of the CCJ's original jurisdiction rules, its case law, the Caribbean community, and the revised Treaty of Chaguaramas. It is additionally an opportunity for students to develop their advocacy skills and public speaking skills. More importantly, however, the Moot allows the students to have real experiences and exchanges with the bench. It is clear to me that the organizers of the CCJ tried their best to create a positive, rewarding, and memorable experience for the students. I therefore must recognize all the players involved in this experience. First, our Moot registry officials, the students who come to us from the University of West Indies, St. Augustine campus. They play an important role in this competition, and as we taught them about the procedural steps and processes required from the filing of cases to the disposition of cases. The students learned about the court's e-filing system, case management processes, and how to provide support to our judges. As you can see, this is a mutually rewarding experience for everyone involved. After a 3-year absence, the Moot returned to the seat of the court. And as you may appreciate, a return to in-person Moot did not mean a return to the usual activity. There was a committed effort to find ways to improve and make the competition an even more exciting and memorable one. We introduced additional prizes and also enhanced our social media promotion of the competition. It is against this backdrop that I must recognize the chair of the CCJ International Law Moot Steering Committee, the Honorable Mr. Justice Burgess. Other critical members of the steering committee are Mr. Noel, our Master of Ceremonies today, but usually our Chief Public Education and Protocol Officer. And someone you heard described earlier as mommy or auntie, our Miss Heather Dyer Thompson, Registry Supervisor. These two officers led their subcommittees well during the planning process. These subcommittees comprised of staff from the registry, the Public Education and Protocol Unit, the Library Services Unit, the Communication and Information Department, the Information Systems Department, the Security and Logistics Unit, the Facilities and Asset Management Unit, and the Finance and Administration Department. Everyone was involved. All these officers must be recognized and their supervisors must be commended today. There were also many volunteers who operated as liaisons and provided overall support. We saw you and we applaud you. But what is a moot competition without its participants? We must therefore extend appreciation to all of the institutions who have continued to express an interest in this competition. These students were guided by advisors, as mentioned before, who juggled their daily duties and these additional responsibilities to ensure that their teams did well. I am sure that everyone will agree that the performances have been riveting and of a high caliber. You all did your best, and I wish to congratulate you on your performances. The Dean of the Faculty of Law at the University of the West Indies St. Augustine campus must also be thanked for the faculty's ongoing commitment to providing students for the Moot registry. We look forward to your continued support in the years to come. To those who joined us online via YouTube, and you who are here with us in person, we sincerely appreciate the support that you have given, not to just us, but the students. I am sure your presence truly added to their overall experience. Our honorable judges, Justices Witt, Anderson, and Rajnath Lee, who formed the tough but kind panel over the last 2 days, must be recognized. Thank you for taking the time from your schedules to lend support to this competition and for giving the students this rich experience. It would be remiss of me not to also extend sincere appreciation to the Honorable Mr. Justice Saunders, President of the Court, and the other honorable judges of the court who continue to support this competition and believe wholeheartedly in its objectives. Well-deserved. Ladies and gentlemen, I am the most recent addition to the team at the Caribbean Court of Justice. I assumed duty a month ago, when most of the plans were already in progress. However, what I witnessed in this short time was a buzz of activity surrounding the Moot, and what can be described simply as passion and commitment. With a team like this, I already know that next year's Moot will be fantastic as well. Once again, I wish to extend warmest congratulations to everyone, the participants and the recipients of the special prizes, to this year's winner of the CCJ International Law Moot Challenge Trophy, the Norman Manley Law School. Congratulations again. I do hope that our specially invited guests will join our mooters as we toast their achievements at the reception hosted on the level above. Our ushers are on standby, ready to direct you. Thank you, ladies and gentlemen, for the courtesy of your attention this afternoon.
And thank you very much, Registrar. And I do hope that you all accept our invitation to toast our 2023 mooters. And I do wish you all a safe afternoon and a really great weekend. And students, I hope you get to experience a bit of Trinidad and Tobago before you return. Those who are going back, and maybe Hewarding and UWI St. Augustine, you all could extend some Trini and Tobagonian hospitality to these students. So show them how we do it. All right? So ladies and gentlemen, have a good afternoon, and please join us as we toast our mooters.